I don't know. After hearing him calm and talking about the tether story, it's probable.
Just go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
Probation. What's going on? This is Colin. How's everybody doing? Happy Friday, part 2. There's going to be part 3 later for my live. 8 p.m. Eastern Standard Time. Come hang out with us. It's always fun. All right. This guy. I don't even know what else to say. Every attorney has fired him. He hasn't fired the attorneys. Every attorney has left his case. And we're going to find out why. You know, there's a very big FAFO moment during this case, and it comes at the very end. And I think he realized it. The defendant. He being the defendant. Let's check it out. Before I hit that play button, you already know what to do. Hit that like and subscribe. Do your jump kick backflips. And if you don't like me talking so much, go to another channel. Let's go.
Leonard Marshall Williams, CR 2372. All right, Mr. Williams, for the record, is set on the court's trial docket. I believe that he is
Judge, he's specially set for trial on June 3rd of this year.
June 3rd, yeah, I was looking on March. So Mr. Williams is set for trial, especially. And my understanding, Mr. Manning, is that you have filed a motion to withdraw as counsel. Is that correct?
That's correct, Judge. And just for the court's record, when that was originally signed, Mr. Williams signed off as agreed on that. However, it's my understanding through his communications with the court that he has no longer agreed to that. So I'm not sure what his position is at this point in time. But
All right, already starting off well. The counselor, the attorney, the guy in the suit, let's say that, has filed a motion to withdraw. The defendant agreed to it, and then he said no after talking. You know, this is just a really good start to a video. Pay attention.
I would say, regardless of his position, I would still urge this motion to withdraw based on the reasons listed out in my motion. And they still do exist at this time.
All right, Mr. Williams, I'm going to give you an opportunity to speak here regarding any inability to communicate between you and Mr. Manning. What I want you to keep in mind is to not say anything about your case that in any way could affect your rights, okay?
Yes,
and knowing that a prosecutor is involved in this hearing, so anything that you say obviously can be used against you in this proceeding, in subsequent proceedings, trial, okay? So can you address for me why it is that Mr. Manning is requesting to draw your case from your perspective?
That's very important. And I'm glad the judge says that. That needs to be said because the attorney's leaving him. The attorney filed this, not him. The attorney filed it. He needs to be able to say, hey, I don't want my attorney to leave me, but this is what's going on. But you have to know how to say it without putting something on record you don't want on record. Very important.
I don't know why you want to withdraw. I don't have no problem, Mr. Manning. I only talked to Mr. Manning. This will be my fourth time talking to him about my case. I don't got no problem with it. I just wanted him to give me my motion for my discovery, my paperwork. That's it. That's all I was asking for.
Mr. Manning, can I go ahead and have you go ahead and argue your motion?
Yes, Judge. I'd say that there are situations that have gone beyond what Mr. Williams has put on the record due to the fact that he's filed multiple complaints about my representation, not only with the court, but with the state bar. Additionally, Judge, I have explained to Mr. Williams in the multiple times that I've spoken with him in our preparation for the motion to suppress, which I did argue before this court previously, as well as our preparation for trial, that he is not entitled to be given discovery, but he can review the discovery with his attorney in preparation for both those hearings, as I said, as well as for trial. I've given him opportunity to discuss and prepare for defenses, but his timeline seems to be a bit different than what I've laid out for him. Additionally, Judge, he's expressed to me his displeasure with his speedy trial being set out to June. He wants the trial. He was requesting a trial date sooner than that. However, Judge, I've explained to him that we have gotten a special setting, which is a specific date for trial that is set by this court, and that's usually done at the earliest available opening, so we have certainty for both parties to be prepared and try that case on June 3rd. Judge, it's my position that if I were removed from the case, that Mr. Williams would have sufficient time to have either an additional attorney appointed or retained who'd be able to prepare for a trial hearing on June 3rd. That gives them well over 3 months to prepare for trial. In this case, the discovery and such that I've gone over, that would be sufficient time for additional counts to prepare for trial. Judge, I'd also just point out for the court that I believe I'm Mr. Williams' third attorney, and I can't speak to what the previous attorneys did or didn't do, but I know both Mr. Weiner and Mr. Stevens and their work product. So, Judge, at this point in time, I would re-urge my motion. I don't think that based on the actions that Mr. Williams taken, that I'd be able to represent him as ethically required to do under the rules and regulations of the state bar.
What is it that Mr. Williams is stating to the state bar? And you said he's filed multiple grievances against you.
Judge, he's filed a grievance as well as filed an appeal once that grievance was denied by the state bar.
And so what is he accusing you of, or what is he alleging?
Judge, I touched on some of those allegations, but without going into attorney-client privilege, I wouldn't be able to further divulge the totality of what he's alleging, but I did touch on some of those in our arguments earlier.
Mr. Williams.
All right, so we know what's going on. The defendant is not happy with his public defender. The public defender tries to back out. So this is the interview that's going on. Wait till you hear the story. Wait till you hear it. You saw him put his hand up. I honestly, the way that he put his hand up, I thought he was going to spread his fingers and do the live long and prosper. I thought he was going to do the Spock symbol. He did not. I was hoping if he did that, this would be a completely different video.
Williams, what are you alleging that Mr. Manning has done? You filed a grievance with the state bar, so you've asked the state bar of Texas to come in and sanction Mr. Manning for the way that he's representing you. What is it that you are asking the state of Texas through the state bar to do to Mr. Manning, and for what reason?
I wasn't asking him to do anything. I was just asking him to do his job. He said after my discovery, he was gonna come see me. He called me out one day to get my mental health paperwork signed over before he can get the paperwork sent to him. He never sent it off. So I'm asking him, could he come and talk to me or something to let me know what's going on with my case? I had got him so quick after Justin that when we went to trial, we just talked that one time and that was it. He supposed to come and talk to me after we did the discovery. He never came and talked to me about the discovery at all.
Mr. Williams, can you just hire the attorney that you want to hire?
No, sir.
Why not? Why not?
Oh, Justin Warner took all my money.
You mean that you retained him and then he withdrew?
Yeah.
For the same reason that Mr. Manning is wanting to withdraw for different reasons.
No, that was a different reason. That with Justin got my money and just withdrew off of it.
Mr. Stevens represented you as well, is that correct?
Yes. Ms.
And why-
Stevens never came to court. I just be trying to get some understanding. I'm a mental health patient, so I be trying to figure out what's going on. Come talk to me. Let me know what's going on with my case. In Dallas, if you got a case, you go on trial, I should be able to see you within that year, not the last 90 days, and we going over something to work up a case. I asked him to file a motion to suppress the evidence to the court. I never got that. I asked, all I asked him to come talk to me and let me know what's going on, where I can be at ease.
And Judge, if I may, just to be crystal clear,
All right. So before this, the defense attorney comes in. The defense attorney has something to lose. So does the defendant, right? The defense attorney can't just do willingly everything that the defendant wants. He can't. He has his bar reputation, his actual reputation, everything that goes along with him as an attorney. Sorry if my wording's incorrect. Anyone who's watching court hopefully understands what I'm saying. But you can't just file everything the defendant tells you to file because it comes back on you. You have to file stuff. Don't say stuff. You have to file motions that make sense. Now, when an attorney gets away with it is when they're talking about bond and you hear attorney say, my client wants me to do this. My client asked me to do this. My client asked me to say this. Now, you're on your third attorney, buddy. You are on your third attorney. You say you paid for your first attorney. I don't know if that's true or not. If you actually retained an attorney, I don't think he didn't show up to court. Otherwise, you would get your money back. You can do stuff. I need to stop saying stuff. You can do a lot of things if that is actually true. He's on his third attorney, and his attorney's withdrawing. He's not firing him. His attorney's withdrawing. Just gonna say, FAFO. You're gonna be in a defendant in jail, not accepting advice. FAFO. Stop being a jail attorney.
you can see in the court's record, I asked the court to take judicial notice of its record. We argued this motion to suppress, and I thought, and Mr. Williams thought at that time, that it went really well. We had some success, scored some points on that motion to suppress, even though the court denied it. We got some testimony I think is going to be favorable at trial. But Judge, as I said, my timeline and his timeline seem to be on two different wavelengths, and his actions have made it more difficult to represent him rather than easier to represent.
I didn't know that to redo the board thing, I didn't know. I thought you're supposed to just fill it out and send it back. I didn't know it was it. I thought that was the end of it. But I mean, this was what it got me. I apologize to him for making the job hard, but I ain't trying to make nobody's job hard. I just wanted to get an understanding about my case.
And what is it about your case that you don't understand?
I'm trying to figure out what kind of move we're gonna go through the court, if he gonna file, or what kind of action do we have. He said he was gonna come talk to me after the discovery to explain to me everything was going on, and I ain't never seen. He said, I see if we go to court, don't go to court and within 2 months, I get your bond reduction. I haven't seen, I'm just back there in my head, just, I apologize to him if I caused any type of harm to him, but I wasn't trying to get no cause, no harm. I was just trying to find out information where he can come sit down and talk to me, where we can come with an agreement where I'll be ready.
I understand, but do you understand what Mr. Manning is saying?
Yes. I apologize, Mr. Manning. I didn't mean none of this, sir.
What Mr. Manning has just said is that while he's been trying to defend you against the state of Texas, you've now put him in a position where he has to defend himself against the state of Texas. So the time that he should be using defending you, he's having to defend himself against you. You understand? You understand what kind of situation that puts him in?
Yes, sir. I didn't know, and I apologize. I didn't know. I'm sorry.
All Mr. Manning, I'm gonna grant your motion. Your
Okay,
motion is granted, you're allowed to withdraw. Mr. Williams, I don't have anybody else on the court appointed list that can represent you. You've gone through them all. I don't have anyone else. So right now you have no attorney. I'm gonna remove your trial off of the special. I'm gonna put you at the very back of the jury trials, because I don't know when I'm gonna be able to get an attorney. I don't know when I'm gonna be able to try your case. So I'm gonna have to go and try to figure all these things out. So these efforts that you take.
All right, I'm gonna let the judge. I'm gonna let you finish. I'm gonna let you finish. The judge is about to give him probably the best advice he's ever heard in this case, at least. The best advice in this case. He's about to tell him. So get your ears up. He does a really good job. But yeah, FAFO. Don't file sanctions against your attorney while he's trying to actively defend you. All right. I'm going to let this play out. There's 2 or 3 minutes left. You all are awesome. Still, second video of the day. Maybe there'll be a third one. I don't know. But I am going live at 8. So anyone that's around, come check it out. Till next time. Bye.
And are going to delay your case even more. And it's through no fault of the court, it's through no fault of anyone else, but based on the actions that you've taken. So I will have my court coordinator reach out soon with paperwork for another attorney if I can find one. So I'm going to encourage you to reach out to your friends and family. If you can hire an attorney, then you hire one. If not, I'm going to need time to see if I can figure out how I'm going to get an attorney in here to represent you. You're on the you're specially set for June. I'm going to leave you specially set there, and then once I get a new attorney, I'm going to remove you from that special setting, and then we'll set you to another time. So at this point, your next court date will be June at the originally scheduled trial date, which was going to be. You were supposed to go to trial on June 3rd. That's not going to happen now. So I'll try to see you before June 3rd, but I don't know when that's going to be. I'm going to have to go find a lawyer somewhere that'd be willing to take your case, and I'm sure they're going to want to investigate, talk to all these other attorneys that you've had to see if they may not even be willing to do it. So I can't tell you anything other than you're going to have to go sit and wait. Hopefully I'll figure out something soon.
Yes, sir, I'm sorry.
That's all right.